Hi, my name is Melissa Exline. I'm with Surratt Law Practice here in Reno, and welcome to the Surratt Law Practice Family Matters videos. Today I want to talk a little bit about the topic of the disclosures that are required in a family law matter before the court. So we have a rule here in the state of Nevada called Nevada Civil Procedure, the Nevada Rules of Civil Procedure, the NRCP, Rule 16.2. So this is the primary rule and the first go-to starting point in deciding what do we have to provide to each other in a divorce case. So I want to share with you a little bit on the screen about the rule 16.2. It's really long, and I'm going to focus specifically on the mandatory initial disclosures that are listed in this rule. Okay, so let's look at this. What does this rule require? So 16.2 is the mandatory pre-judgment discovery requirements. And this is not including paternity and custody action. So it's really talking about a divorce case. And this also addresses the financial disclosure forms and what's required there, but that's for a more detailed blog on that issue or another discussion on another video about that issue. I want to focus for today's discussion about the mandatory initial disclosures and what's in this on that issue. So you are required in a divorce case, even before being asked from the other side, to provide evidence supporting the information in your financial disclosure form, and you have to share information on the property, income, and earnings of both parties in the case. So this requires going through the information, the bank statements, credit cards and debt statements, real property documents that you have. It includes deeds, deeds of trust, purchase agreements. Go through this rule and make sure you're familiar with it. So you can look up Nevada Rule of Civil Procedure 16.2 or NRCP 16.2, and this information is available online for you to look up and make sure that you're complying with this rule. You have to provide loan applications, promissory notes, deposits, receivables, your retirement and other assets. You have to provide copies of all monthly and periodic statements for your pensions, retirement, stock options. It goes on for at least 6 months. And that's the minimum look back from the time that you're initially required to provide this. And then as the case goes on, you have a duty to supplement, to provide ongoing information during your case about all of these different assets and debts that you have. So you have to keep it current and provide the actual information while your case is ongoing. So you have the rule goes on insurance policies, values, tax returns, proof of income, and that includes W-2s, 1099s, K-1s for 2 calendar years, as well as the year-to-date income information that you have if you don't have, so if you have the 2 prior tax returns and we're in the middle of 2020 or something like that, then you have to provide at least the last 6 months of information for where you're at prior to the summons and complaint being issued. And then you have to provide information on your personal property. It says here that anything that's over $200 in value, and often my tip for that is just to make sure that you list the major items that you want to address in your case and at least share a request list with the other side about what you'd like to take from the divorce when you're done. So any exhibits have to be provided for everything in your case. And the key here that I want to impart when we're talking about this rule and what you have to do is it's pretty daunting. It's asking for quite a bit of information. So if you're thinking of filing a case and you're thinking of going to an attorney, it's a good idea to start culling together all of these documents, grabbing the information so that you have it at your hands when you do your first meeting with your lawyer. This is really, really helpful when I have someone come in and they're organized and they've taken a look at it. And maybe they don't have everything, but they've looked at it and I know that they're actually digging into the documents so that we can start by hitting the ground running instead of going backwards and looking up all this stuff after we've already moved forward with the case. So it's a good idea to do that and get ahead of the game, just because there's a lot there. So my other suggestion with this is is that, you know, nowadays a lot of people will have this information in their computer. You can put it on a disk, you can put it on a thumb drive, you can put it in a Dropbox or some other share file system, and you can get it to your attorney that way. Even if you don't have an attorney, though, you have an obligation to get this information together. And the reality here is that you are showing and putting all your cards on the table. One of the things that I think people misunderstand about divorce cases is that there's some sort of mandatory hide the ball thing going on. Really, truly, the court is not interested in playing games, and they want everybody to be on the up and up and have all their cards on the table. And so in this case, our cards are our statements, and we put all of those statements out there into the world so that you're giving that information and sharing it, and we're not wondering if the other side has given us something or hasn't given us something. Even before being asked, you're supposed to provide this list of stuff, and if you don't know if you have it, you need to say you tried to look and you're not sure. So that way you're putting all your cards on the table and making that very clear. So I hope that helps you out there, and that you guys can be organized if you're ever facing a divorce, and you can come prepared and show your information is honest and truthful, and you can get to a resolution quickly. So with that, thank you for visiting us, and keep tuned into this channel. If you guys have more questions, let us know, and you can always reach out and get more information on our website at lawyersforfamilies.com. Please feel free to reach out and give us a call as well at 775-636-8200. Thanks so much.